She and her students just in the last 2 years have helped clear the names of innocent people, including Darryl, Pinkins, Roosevelt, Glen, who will be speaking next after Fran, and William Barnhouse. Essentially, Professor Watson's dedication to justice, use of scientific technology, and pro bono efforts exemplify the mission of the nonprofit Justice Through Science, which is your host today. And so we're presenting Professor Watson with the first Justice Award from Justice Through Science. And it's the award. This is Professor.
Right away. I'm going to say, I accept this for our team. Okay? I accept this for my client, Roosevelt Glen, and his family, and these two scientists, Dr. Pinkins and Dr. Perlin. But for their work, without pay, Roosevelt wouldn't be exonerated, and Mr. Pinkins would still be in prison. And so I accept this for our team, and I'm very proud. I'm very appreciative. Thank you very much. Okay, so Pittsburgh, lawyers and scientists, you're close to Friday afternoon, and I always start, when I even talk to a class in law school, I say, I consider myself a lawyer and a teacher. I even say to my students, just call me Fran. Just call me Fran. Because I really do see myself as a lawyer. I still feel like a lawyer, not a professor. And I want to say that I have to say this, that I love being in Pittsburgh. My grandfather worked in the mills for many years before he went to the coal mines of Kentucky, and he was a hardcore Pittsburgh Steelers fan. And I remember Franco Harris. There have to be people in this room that remember. And so I still to this day remain a major fan of Pittsburgh sports, even though I'm from Indiana, okay, and we don't have any lack of sports and devotion to them. So I think this is your ethics credit today. And what I'm going to do is talk about the Pennsylvania Rules of Ethics, which is a great segue, perfect segue. And then I'm going to tell you a story about this case, and we're going to talk about whether or not the lawyers were ethical. Did they do anything unethical in the course of a trial in which there were a lot of mistakes? So I get this famous... So we're going to talk about the ethics of wrongful conviction, and we're going to use the Pennsylvania Rules of Professional Conduct, which it turns out are just like the Indiana rules. There's no difference. They're almost word for word identical. And I always start these talks with the human faces of wrongful conviction. This is Mr. Glen, you see, and Mr. Pinkins. And these are people who spend... Mr. Glenn spent 17 years. Mr. Pinkins spent 25 years in prison for crimes they didn't do. What you need to understand is these were working men, never before arrested in their lives. They had families at home. They worked all day and were paid that day. So it's a travesty in more than one way, and lawyers played a role. You learned a lot about DNA today, and no doubt many of the lawyers in the room sat there and thought to themselves, how am I ever going to understand this? And the answer is you have to. You have to get to the point where you understand it, because it's going to be more and more in the courtroom, and we're turning the page to probabilistic genotyping. I totally agree with the prosecutor. This is reliable, it's good science, and it can solve cases and bring justice to the criminal system. It's the real deal. I'm convinced of it. So here's our rules. Here's the rules of lawyering. I often start with students and say, come on, guys, who's had ethics? And they raise their hand. And then I say, who remembers the first rule of ethics? And the students go, they had the class, but they don't understand. The first rule of our business is, as you said, we're supposed to be competent. I put that, it means you're not supposed to leave the patient worse off. And you know, as you sit here this morning, that competence now means, in many of these cases in criminal court, you got to understand DNA. You have to either present it or stop it from getting in, depending on your side and your case. So if you want to be a lawyer these days and you want to do criminal work, this is your first rule. This is our first rule, and you need to understand science. We all know what's the second rule. That's the client's control, right? It's not our decision. When you're a criminal defense attorney, you need to live by this rule in some ways. The client's objectives control. Doesn't mean you can't talk them out of it if you're skilled enough and it's reasonable, but the client's objectives control. Diligence. When the story that's to come about Mr. Pinkins and Mr. Glenn has a lot of moments at which I would argue the lawyers weren't diligent. You're supposed to be reasonably diligent and prompt in representing a client. And in part, couple that with competence. Again, it means put on your science hat. I don't know how many in this room went to law school because they didn't do well in math and science. Anybody admit that? That you went to law school because you like to read and you like to write, but the math didn't just flow. And if you're one of those people, you might have to work harder. Communication, you're supposed to talk to your client, right? Consult with your client. Should I test the DNA or not? Not to offend anyone, but I call that the come to Jesus meeting. Let's discuss whether we're going to test this. How about 3.1 in your state of Pennsylvania, your rules of ethics, it says that you're not to assert or controvert an issue unless there's a basis in law and fact, but you can make a good faith argument to change something. And of course, lawyers, as we just heard, in criminal proceedings, they can stop the state's proof, even if we're not after truth when we're criminal defense attorneys in most cases. We're after stopping the proof. That's the rule. I say to my students, the rules of ethics are like a box for a lawyer. You get in them, and they control your decision making. They're supposed to be the construct. And then I try to explain to students, lawyers get in the box of ethics, and then what do? We go in a lot of circles, moving around issues and options, figuring out law and facts until we come to decision making. That's the way I try to explain to new students what we old lawyers are doing, day in and day out in our heads. Candor toward the tribunal. We've just covered this. If you're an attorney and you're misrepresenting facts in the courtroom, you're being unethical. You may even be violating the Constitution. But in terms of ethics, it's unethical to knowingly present false evidence. Of course, in these many cases of exoneration, when do you know? When do you get to the point where you know you're presenting false evidence? You just heard that cybergenetics and star mix differ sometimes in the results they get when they do tests. So are you presenting false evidence if there's two sides and they differ? I'd say no, as long as you have a reasonable good faith basis for believing in your evidence. How about fairness to opposing party and counsel? We know this one, right? The business wouldn't work if we couldn't trust each other. Now remember, I've been a criminal defense attorney for decades, and there are prosecutors I do not trust, right? But that comes from experience. You know the lawyers that look you in the face and tell you the truth. And don't we as lawyers sometimes talk about the ones we don't? We talk about the lawyers who we don't trust and aren't candid and aren't truthful. It gets around in this business. How about trial publicity? The idea is that if you're a prosecutor, you are bound by this rule, and you're not supposed to make an extrajudicial statement that you know or reasonably should know will be disseminated and is likely to have a prejudicial impact on the proceeding. And here's one of my favorites, special duties of prosecutors. You have this in Pennsylvania. We have the exact same rule in Indiana. I say to prosecutors, you're the only ones that have your own rule. You have your own rule of ethics because you have the power. You oftentimes have the discretion You can sit behind these desks and send that man to prison for 17 years for something he didn't do. Prosecutors. And so prosecutors have their own rule, which is you should disclose to the defense all evidence or information. Doesn't mean it has to be admissible, known to the prosecution that tends to negate the guilt of the accused or mitigates the offense. In a lot of these exoneration cases, in my experience, this doesn't get done. The exculpatory information never sees the light of day during the first trial proceeding. So now to my story, okay, if you will. In the beginning, keep in mind, everybody, there was DNA before there were lawyers and scientists. There was DNA in the nucleus of your cell, before there were books. So this story of this exoneration is one of time. Here's what a DNA strand looks like inside the nucleus of your cells. Here's what that double helix looks like. That's that strand inside the nucleus of your cells. And we all understand, right? You got one from your mom and one from your dad, and basically those numbers come together. And what DNA is measuring is the traditional DNA method measured a repetitive pattern at a location, and you should have two of those. You should have two markers at each location on your genome. They might be the same. In other words, you could have gotten a 16 from your mom and a 16 from your dad, but you should have two numbers. And so here I offer a little bit of a DNA timeline, right? DNA's in we're carbon-based life forms. That's everybody in this room. And DNA goes back into the 1800s. They started isolating the genome. They got around, in 1953, Watson and Crick wrote of the double helix for the first time. In 1984 is when DNA profiling was developed at a university in England, not in a law enforcement lab, in a university lab. Cellmark bought rights to use this technology, and you don't see it in the courtroom in the United States until the late 1980s. It's just not there. It's new. And I like to add onto my screen that FBI lab that did DNA was established in 1988, and cybergenetics was founded in 1994. Thank goodness. Okay, for me. And here's the timeline of the case. There's DNA out there, and there's a 1989 crime. So in 1989, DNA's new in the courtroom. And I want to suggest that most lawyers don't understand it now well enough then. There's probably more people that understand it now, but my guess is in 1989, lawyers were a bit lost. There's a 1989 crime. Mr. Pinkins and Mr. Glenn were convicted. They took their appeals. They end up represented by this wrongful conviction clinic that I direct. Dr. Hampikian, who you'll hear from later this afternoon. He was our expert witness in the original post-conviction case. He's the one that explained to me about this mixture problem. And Dr. Hampikian would see me at conferences for years, and he would say to me, Fran, science is going to solve this. There's this scientific technique out there that's just being developed that may be able to solve the mixture problem in this case. So eventually, Dr. Perlin and cybergenetics and his team, Bill and Matt and everyone here, they dissected that mixture, and the clients were exonerated. 5 people committed this bump, rape, and rob on a woman in Lake County, Indiana, late on December 7th, 1989. And the victim said from the beginning she had been out drinking that night. She stopped by the house of 2 men on the way home. We've always speculated what she was doing there. I personally think she might have stopped by for more drugs. She was bumped, got out of her car, and assaulted. And there had been a series of these bump, rapes, and robs in Lake County, Indiana, just south of Chicago, for some period of months. So women had been warned about these crimes. They were ongoing. They were actually ongoing after the clients were arrested and incarcerated, but the state argued those were copycats. The victim said that all 5 men ejaculated, and she was quite succinct about that statement. So are you beginning to see we've got one of these DNA mixtures here? Eventually, the police arrest 5 men, Pinkins, Glenn, Durden, Jackson, and Daniels. And they arrest them at Luria Brothers, which was the mill that they worked in up in Lake County, Indiana. Roosevelt will tell you a little bit about that experience, I think, at lunch. Charges are filed in January of 1990, and there were no IDs. There were no IDs. The victim could make no IDs. There was no physical or photo lineup. None, ever. Instead, what the state had was a pair of coveralls that had been left with the victim after the crime. What would happen is the assailants would bump the car. The victim. This was before cell phones. You couldn't just get on your cell phone and dial 911. The victim would get out. They would grab her, put her in the car, their car, and drive around and assault her. They also robbed her. But when they left her back at her car, they threw a pair of coveralls at her. And those coveralls became the key piece of evidence against Mr. Pinkins and Mr. Glenn. Why? Because the police traced those pair of coveralls to this mill. I'm sure we're in Pittsburgh, right? You know about steel mills? And coveralls are distributed by mills to workers. The mills own them. They give them to the workers so they don't get burned or injured on the job. And this pair of coveralls was traced back to the mill. And when the police officer got there, he thought he had his bad guys. Because 3 men, Mr. Glenn, Mr. Pinkins, and Mr. Durden, had returned to work the Monday after this crime and said our coveralls got stolen. For many years, I would explain this case by saying, look, it comes down to whether or not you believe their coveralls were stolen. If you don't believe their coveralls were stolen, then they're lying. If you believe their coveralls were stolen, the bad guys took them and left them with the victim. Here, this is from the Court of Appeals decision in Pinkins. It was determined that the condition of the greens that the victim had in her possession was consistent with Mr. Glenn's coveralls. And each had been issued this new pair of greens on December 11th, 4 days after the assault. So according to the state, these men committed this crime and then went to work Monday and reported their coveralls stolen, knowing that they had left at least one pair with the victim. By the way, the police never found any of the other coveralls that had been stolen from the car that night. So, a couple of days at the time of the arrest, the victim said to the police, I can make no identification. I had been drinking, my head was covered, I didn't look, I can't ID anyone. She described 5 black males, punk talk, in their early 20s. The officer, this is undisputed, Detective Solon, took the 5 mugshots of the 5 men he arrested to her house to show them to her. Now, how many prosecutors in the room think that's okay? Any prosecutor want to say that's good police work, to have a victim telling you, I can't make an ID, and instead of doing a photo lineup or a physical lineup, taking the 5 mugshots of the men arrested to her house with the purpose of showing them? If you were a prosecutor, would it be ethical to use that? If she had made an ID? Ethics is a matter of skills and judgment, right? You have to use your judgment. It's rarely going to be on these tough cases that make you grimace. It's rarely going to be that you get to a situation where you go, oh, that's easy. So they take the pictures to her house to show them to her, and her testimony becomes, I refuse to look. My husband looked, I didn't look. The testimony. My husband was sitting at one end, and he said, here's the pictures of the people we arrested. Here's the pictures of the people we arrested, and I don't want to look at them, and she said she pushed them away. She did admit later that she might have seen the ones on the top. I think that was you, Roosevelt. So, they in the beginning, they have no ID, and they have 3 men. They arrested 3 men who'd have been together that night, and additionally 2 other men that also worked at the mill. And sort of what starts the nail in, your time in prison was that there was this hair that they took off the victim's sweater. It becomes Exhibit 71A, and someone from the Indiana State Police Lab testified that the hair from the victim's sweater was of common origin to Mr. Glen. In other words, the matchword. They used the matchword. The hair from the victim's sweater matches Mr. Glen. Well, of course, years later, we were able to show by mitochondrial DNA testing the hair didn't have a root, couldn't get nuclear, but we could do mito, and it wasn't his hair. Now, back in 1990, when the analyst said, I looked at it microscopically, and it is his hair, that was considered the state of the art. I mean, I can't blame the prosecutor, if you will, for using the science that at the time was thought to be science. Since this time, of course, we know that microscopic hair comparison has been discredited and is no longer used, in part because we have a better tool, DNA. So this is just a copy of the lab report where the analyst at the state police lab said, "Oh, the hair from one of the hairs from the victim's sweater is Mr. Glen's hair." Now that's not why he has no hair. No, it wasn't his hair. Okay, so what happens? What do they have now? They have the coveralls. They have a hair that they say belongs to Mr. Glen. And they have the victim come to the courtroom 5 months after the crime, and the one and only ID of any of these defendants was made in the courtroom at a pretrial. And she identified Mr. Pinkins, a co-defendant, who happened to be 37 years old at the time. He does not talk punk. And she related to the prosecutor and the police officer. As soon as I saw him, it came to me. That's him. That's the first man that approached me. And so going back to ethics, I'd ask, are there any prosecutors in this room that might question the use of that in-court ID? I mean, my experience would be you might question it, but you'd go forward with it as long as you had a good faith basis. You'd leave it up to the defense to cross. Right? You'd leave it up to the defense to cross. Anybody willing? Any prosecutors willing to say, I'd set that ID aside and tell her we're not going to do an ID? It'd be hard in this case. They needed that ID. They had a hair, and now they've got an ID. So meanwhile, remember, we're in 1989, and DNA is new, and they've sent the DNA out from the rape kits. And there's biological material there for sure. And the law enforcement have every reason to believe this is it. We're going to get results back. It's going to include these men. This is going to be a cha-ching. We're done. And guess what? The DNA came back in August 1990, and it excluded them all. So now you're really sitting there saying, 17 years in prison, 25 years in prison, they were excluded by DNA. But they've got an ID, and they've got a hair. So the DNA comes back and says, well, there's seminal stains on the jacket, and there's stains on the sweater, and they're not from Durden, Pinkins, Jackson, Daniels, or Glen. They were all excluded. The state took the position that didn't mean they weren't there. In fact, I love this note. This is a note from the detective. He goes to the victim and he says, on 9/11, I, Mike Solon, notified Mr. and Mrs. Wimmer that the DNA tests were concluded and there were 2 exclusions. So the police officer goes to the victim and doesn't say they were all excluded. The police officer said there were 2 exclusions. Why? Well, because from the ability of the science at the time to look at the results from that jacket and sweater, they knew they had a mixture. They knew they had a mixture, but what they were looking at seemed to be two genotypes that were very strong. One from the jacket, one from the sweater. So the police took the position, we're right about Durden, Pinkins, and Glenn. It must have been those 3 and these 2 unknowns. And so the police officer goes to the home of the victim and, in my opinion, cements her belief in the guilt of these men by saying to her, the DNA's back and we've got 2 exclusions. They really had 5 exclusions. So what does the state do? The state amends the charge, drops Jackson and Daniels, and proceeds against Durden, Pinkins, and Glenn. And there wasn't any doubt from the moment Durden, Pinkins, and Glenn were arrested, they all acknowledged we were together. We drove home from work in Durden's car. The car broke down. State trooper actually saw them walk away from the broken down car. When we got back to the broken down car, the wind had been busted out and our coveralls were gone. So were their lunch pails. Whoever broke into that car, out doing bad acts, broke into that car, grabbed their bags, and left. They go to trial after they amend and here's one of the parts that I find the most unethical, is that the state of Indiana used serology inclusion evidence in the face of those DNA exclusions. Now you should understand, if you don't already, that serology is a generalized identifier. It can put you in a group, okay? It can group you, but as this man taught me, it can't individualize you. They had been taken out of those mixtures by the greater test. But guess what? The defense attorneys didn't understand. The defense attorneys didn't even make arguments to say those serology findings are more prejudicial than probative. The lawyers, DNA was so new and it was tough, and they just did not understand that in the face of a DNA exclusion, you can't come in and say he could be in there by his blood type. And the testimony on the serology went on for hundreds of pages. They really landed that serology. The witness sat in the witness stand and, gave her credentials and just went on and on and on. They even had a chart. And this chart was wall-sized at the time, and they listed Durden, Pinkins, and Glenn, and they showed all the evidence, and they call it a genetic marker summary. So in the face of DNA exclusions, they put on serology inclusions. I find some incompetence on the part of the defense attorneys for not working harder to figure it out. And I call into question the ethics of the prosecutors. I think over time they came to understand that doing that was essentially false evidence. It's false to tell a juror that he's in this stain by serology when he's already out by DNA. So, Mr. Pinkins, his guilt was in 91. He got 65 years. He pursued in Indiana what we call a Davis-Hatton. In other words, look at that. His lawyer had sleep apnea, slept during the trial. There's a case out there in Indiana called Pinkins versus State, where the Indiana Court of Appeals actually says the lawyer only dozed during the serology. And the lawyer's testimony had actually been that he had sleep apnea and he dozed all the time, especially during the long, boring, complicated science parts. Those facts never made it into the decision. But so Mr. Pinkins contacts the clinic. There was further DNA testing. So, things changed in DNA land between 1989 and 2001. did testing again in 2001, and we basically get the same results. We don't have probabilistic genotyping yet. We get the same results. There's somebody on the sweater, there's somebody on the jacket, and there's others in there. So we take, Mr. Pinkins goes through a denial of the PCR. He goes to federal court. He loses his federal case in 2007. He remains in prison, and until we get to the point where we can file a successor request in Indiana. In our post-conviction world, you get one bite of the apple, and if you want that second bite of the apple, you have to get permission to go back. And so we call those successors. And what we did, let me go through Mr. Glenn. Mr. Glenn, his first jury deadlocked in 1992. What does that tell you? His first jury convicted of nothing, mistry. They go to trial again in 1993, and he's convicted of one of 3 counts. He's sentenced, therefore, to 36 years. He does his direct appeal. We come back in 2003, we file his PCR, and that's when Dr. Pinkins gets involved and explained to the court that the serology should not have been admissible in the face of those DNA exclusions. And we also were able to show in Roosevelt's PCR that it wasn't his hair. But what did the Indiana court do with that? They said you didn't show a reasonable probability of a different result because they've still got a victim ID, and there were snitches. There was snitch testimony from the jail. So the court says the fact that it's not his hair and the fact that there was serology in the face of DNA exclusions doesn't convince us that there's a reasonable possibility of a different result upon retrial. We were devastated, obviously. We were devastated. It felt unbelievable. But, as I say, Greg stayed on me. He would say, don't give up, Fran. Science is going to deal with this. Science is going to get to where they can look at that mixture and give you more information. And that's what happened. So we lose our first round, and we decide with this new science, we'll try again. We'll try for a successor. We got the data to Dr. Perlin. I was so unknowing about the whole process, I sent it to him in the beginning, hard copy. And they call back and go, we need the disc. Yeah, I'm like, they didn't want the hard copy, they wanted the data. They wanted the raw data. So we try again on these basic allegations in post-conviction land about ineffective assistance, violation of due process, and newly discovered evidence, right? That's how you go back to court. If you're in my wrongful conviction clinic and we want to get somebody out, it's going to be one of those 3 ways. And in the case, again, we had serology inclusion in the face of DNA exclusion, this faulty hair comparison, snitch testimony, and what I would claim to be a faulty ID. There was also, I have to introduce Exhibit 59D because this becomes critical to Dr. Perlin's, I was about to say diagnosis, but to Dr. Perlin's results, is there had been this hair that had been taken from the combing of the victim that was never tested. And it actually had a root. The hair that they had said at trial, 71, the hair at trial they said matched Roosevelt's, didn't have a root. So back in 1993, they couldn't have done nuclear. They matched the one hair up, they couldn't test nuclear. They don't test this hair, which is 59D, and we test it in the post-conviction proceedings, and we get a genotype. And it's not them. But we do have, from this hair, a full genotype of one person. We know it. This isn't a mixture. This is the person who left the hair. Here's their genotype. And I want to move through this so we're timely. I want to note that the head hair, we were able to show in the post-conviction proceedings that the head hair that the expert had said was of common origin to Roosevelt's wasn't even a match microscopically. we had our own expert look at the hair microscopically, and the expert said that should have never been said to be of common origin because it's not the same length and width. And if you're microscopically comparing hairs and they're not of the same length and width, then you don't go to step 2 about color and density. And in this case, they had done that. So we were even able to show, we believed, that they should have never said it was his hair, even microscopically. And there's that hair. You can see where the root had been destroyed on the edge of the slide. They actually destroyed the root of the hair when they put it on the slide. And we were able to show again that it was not Roosevelt's hair. And what we're up against in this successor is newly discovered evidence, right? We've used up ineffective assistance. We used up the Brady violation. They knew or should have known that they were using false evidence in the form of serology inclusion in the face of DNA exclusion. So what we have left at the successor stage is Dr. Perlin's findings, which I will share with you in just a second. And we know that our issue is really going to be number 9, that it will probably produce a different result. We have to convince the court that this does make a difference. And again, as I said, it was Dr. Pinkins and Greg who stayed on me, bolstered me when I would get down and say, science is going to get this one done, Fran. And he, in fact, wrote to producer at 48 Hours, a lady named Judy Rybak, and he said, Francis can correct any errors, but there's this former director of Cellmark, DNA expert on the case as well, and we agree this is one of the worst cases of clear injustice he's seen. Now, that's good to hear, but when you're the lawyer that lost those PCRs, it's hard too. See, it's a clear case of injustice. I was fighting hard to be competent and diligent, and we didn't get it done. Until we get 48 Hours and cybergenetics involved. And Judy Rybak actually visited Mr. Pinkins and Mr. Glen in January of 2014. It's kind of an interesting little story. She goes and visits him. She goes back. She's convinced that they're innocent. She meets Roosevelt and his family. She sees Mr. Pinkins in the prison. She goes back and she tries to convince her boss producer to do this story on 48 Hours. And she calls me up one day and she said, Fran, you know how much I believe in this case, how much I want to help you, but my producer says it's too complicated for TV. Now, it is complicated, right? I'm trying to explain it in my given 40 minutes, but it's got some layers. And her first reaction was, it's too complicated. Well, 48 Hours isn't going to get involved, but Dr. Perlin's bought in via Dr. Pinkins, and so I'm moving forward. I don't need 48 Hours. I need the science. And then about a year later, 3 months before we had actually the hearing, the evidentiary hearing where we were going to present this evidence, Judy Rybak calls me up and she says, Fran, my producer just came into my office and asked me whatever happened to Pinkins and Glenn. And I say to her, well, law's slow and I'm still on it, but we actually have a hearing set in April. We're ready to roll. And she says, well, my producer said, Making of a Murderer is popular and it's complicated. Maybe this isn't too complicated. And I was like, really? Okay. Now, I'm not one of those that watched Making of the Murderer, you see, but I was so glad to hear her say, we'll do it. And 48 Hours gets in 4 months before the hearing. And I say to this day, it was the straw that broke the camel's back. Because why? They were going to be in that courtroom. Whether they got their cameras in the courtroom or not, they were coming to the courtroom and they were going to put it on national TV. Are there any prosecutors in the room that would have no impact on?
Not a lot of cameras here.
Not a lot of cameras?
Not a lot at all here.
They're on in Indiana either, I'll assure you. They would not let 48 Hours in the courtroom with their cameras. I mean, they worked hard, and the answer was no, no, and more no. But didn't mean they weren't going to sit there and listen. We get Dr. Perlin's affidavit in April 2015 and his report in September of 2015. And guess what? We now have all 5 of the bad guys. And the 5, they're not Darryl, Pinkins and Glenn, Jackson Daniels. They had the wrong men from the beginning. They let the bad guys go. I call this scientists to the rescue. We need science, okay? We need, there is truth in science. And it's going to be the future. It's going to be real hard to be a criminal lawyer, either side of the game, going down the road without some understanding of science. Some cases you'll have to get it in. Some cases, yes, absolutely, no question in my mind. I'll make the argument against in one case and make the argument for in another. I'm a lawyer. I understand my job. But science can take you to truth. And so cybergenetics does, I don't know how many runs you said you did. I do not pretend that I really understand what True Allele does. I understand it's an algorithm. I understand it's based on Bayesian math. I understand if you just think about it, he's calculating probabilities of numbers at certain locations on genomes, and that's about as far as I can go. But it's the future, in my opinion. So, what Dr. Perlin and his team at Cybergenetics found, he was able to unequivocally show the genotype on the jacket, unequivocally relatively show the genotype on the sweater. Here's the chart. It's not far from perfect, but you will see that on this chart, if you were to ask for it and look at it with the ability to actually see it, you would see that the cybergenetics data is in the beginning, and it's compared to the cell mark data at the bottom. And the reason the case had always been relatively complicated is it turned out that the assailants were either brothers or cousins. And that's why there's so much overlap at the locations. They're related. So, what we were able to show after the cybergenetics testing was that there were 2 majors, there were 2 minors, and see, before True Allele, you couldn't use the data that was the minor because it didn't fit the protocols. His program doesn't discard data. And so we had, at the end of it, the 5 bad guys. We were able to say, look, we've got 5 bad guys, and they're not Mr. Durden, Mr. Pinkins, Mr. Glenn. Therefore, your argument that it was these 3 men and 2 unknowns no longer holds water. I particularly liked that we had 3 majors. So where's the 3 majors up there? 1 from the jacket, 1 from the sweater, and Exhibit 59D. And Dr. Perlin was able to show that whoever left the hair on the victim was a different individual, but related to the person who left the stuff on the jacket and the sweater. And so at that point, I really have 3 solid genotypes, and it can't be Darryl, Pinkins, and Glenn and these 3. And so here's what happens. We're ready to roll. They're flying in. We're going to have this big hearing on Monday. 48 hours is camped out. And the prosecutor calls me Thursday night and says, Fran, we're going to dismiss. And did one of those things, some of you will relate to this, did one of those, we're going to dismiss, Fran, but we can't get the paperwork done by tomorrow, so we'll have to call off the hearing. And what do you think I said? Yeah, no, we're not calling off any hearings, okay? I want my court order, all right? And when I get my court order in my hand that says this conviction is vacated and you dismiss, I'll call off my hearing. And we got that court order on Friday. Of course, we get it on Friday and Mr. Pinkins is still in prison and we think we can get him out Friday afternoon. And did that happen? No. But it did happen the following Monday. And this is Mr. Pinkins hugging his family outside once he's been released. And here's Roosevelt, and here's Roosevelt greeting Darryl as Darryl comes out of the Lake County Jail on this day that I call Justice Through Science. We got the client out. We made their families whole again. And the only reason is because of the science that is true allele through cybergenetics. So thank you very much for your interest. Thank you very much.